We need to break down the United States Department of Justice's brief in the Barnett case a little bit more. Specifically, I want to talk about three particular things associated with the filing of this amicus brief in support of the Second Amendment in the United States Court of Appeals for the Seventh Circuit, which is the case, of course, arising from the excellent work and the excellent opinion by Federal District Court Judge Stephen McGlynn. Let's break it down and analyze what did the Department of Justice say beyond the basics that I've already covered in a prior video. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have previously covered the great breaking news that the United States Department of Justice under President Donald J. Trump, with the guidance of Associate Attorney General and the head of the Civil Rights Division, Harvey Dillon, Chief of Staff to Pam Bondi, the Attorney General, that's Chad Mizell, Jason Mannion, and several other lawyers have done a great job advancing the right to keep and bear arms in America, including in our court systems, and we're just starting to see it really take off right now. And the most recent example of this is the amicus brief submission, a friend of the court submission, by the Trump administration in the United States Court of Appeals for the Seventh Circuit, which of course is a three-judge panel, which includes Judge Frank Easterbrook, a tremendous disappointment to the conservative legal movement for reasons we've talked about in prior videos. Anyway, this is the three-judge panel in the Barnett case. There's a series of cases that have been consolidated. All these cases arose from a multi-day trial in front of federal district court judge in the United States District Court for the Southern District of Illinois, Stephen McGlynn, who is almost definitely on the short list to be and sit on the United States Court of Appeals for the Seventh Circuit down the road. Now, Judge McGlynn, as you may recall, issued a very long opinion with a series of findings of fact after a multi-day trial. And he then entered essentially a permanent injunction enjoining the state of Illinois from enforcing many aspects of its gun control law, including essentially its ban on semi-automatic rifles, AR-15s, and magazines that hold more than 10 rounds and so on. I'm summarizing the essence of what the holding was and what the Illinois law that was being challenged in that case was. Now, despite the entry of an injunction by the federal district court judge, Stephen McGlynn, it was promptly appealed by the state of Illinois. And of course, the U.S. Court of Appeals for the Seventh Circuit enjoined, or really stayed, technically speaking, they stayed the federal district court injunction. The injunction was going to stop the enforcement of this Illinois state gun control law. And the Seventh Circuit immediately stayed, which means put it on a pause or put it on a shelf or just hit the pause button, whatever metaphor you want to use, Judge McGlynn's ruling in favor of the Second Amendment. And that's where we are right now. And there is now briefing going on in that Barnett case, which is really, again, a series of cases that have been consolidated under the name of Barnett versus Rao, pending in the Seventh Circuit. Now, the Trump administration filed a powerful brief a few days ago in this case, arguing that indeed Illinois' bans on these various types of arms violate the Second Amendment. They also took the position, and correctly so, that things like suppressors and magazines that hold more than 10 rounds and other items that help a firearm fire are protected arms under the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed, and that these various items are arms, and that under long-standing Supreme Court precedent and the history of American gun law, you cannot ban any of these items. Now, there's three things I want to talk about in this video to make you the smartest person in the room. This is a little bit of a deep dive, but you're going to totally appreciate it. It's going to be very clear when we're done with this, where we're going with this. But there's three particular things, in addition to the obvious points that I previously made in a video about this. We've already talked in detail about this. You can check the video out from a couple days ago where I broke this down as breaking news that the Department of Justice had done so. But there's three additional points I want to bring to your attention. Two particular points that I thought could have been made by the U.S. Department of Justice to bolster or strengthen their argument, and then answer the question, why do we think the Department of Justice followed this amicus brief in the Barnett case as opposed to perhaps another Second Amendment case? So let's just start with the two areas of, in my view, in my opinion, that could marginally have improved this excellent brief. Now, again, this is an excellent legal brief from the Department of Justice in all respects. So the fact that I'm making these two observations about how I might have improved the brief had I seen the brief ahead of time as kind of a lawyer on the case, hypothetically, these are the two things I would have had added to the brief beyond what was said. And it doesn't impact the outcome, it just strengthens the argument. The first thing is, this Department of Justice brief does an excellent job of analyzing the text of the Second Amendment and then comparing it to the history. Now again, the way to understand the Heller-Bruen methodology is that Bruen was essentially laying out in sippy cup fashion, in paint-by-numbers fashion, the text first, then historical tradition analysis that was really done first and foremost in 2008 by the Supreme Court in the Heller case. But because the lower courts screwed up that Heller methodology so often, Bruen basically reiterated the Heller methodology of text first and history second in a paint-by-numbers way to make it harder for lower courts to mess this up. And this Department of Justice brief does a really nice job of that. And again, the way to understand the text is, at the textual level, the question is the proposed conduct by the gun owner, if you will, either the actions the gun owner took or the actions the gun owner wants to take, is that conduct fall within or implicate the text of the Second Amendment? The right of the people to keep and bear arms shall not be infringed. Now, this first step is really a semantic process or a linguistic process, meaning really all it's about is you take the relevant gun control law, or you take the conduct of the plaintiff, in this case, the individuals that want to own AR-15s, semi-automatic rifles, magazines, hold more than 10 rounds, whatever it is. They want to own suppressors, whatever it is. And you line that conduct up against the text of the Second Amendment as that text is defined semantically or linguistically. It's a linguistic language analysis. And the only role of history at that level of text, or at the textual level of analysis in the Bruen methodology, or Heller-Bruen methodology, the only role for history at the textual level is it identifies the time period in which you want to figure out what the words meant when they were written, in this case 1791, which is why the U.S. Supreme Court in Heller, for example, in consulting what the words of the Second Amendment meant, they did not use a dictionary that was published in the year of our Lord 2008. They used dictionaries that were published back in the 18th century, early 19th century by Noah Webster, the American lexicographer, who talked about American English, and Samuel Johnson, the English lexicographer, using English, if you will, or British English. And they define arms to be anything that can be used offensively or defensively, and so on. And then, of course, once the text is implicated, the burden shifts to the government, and the burden is on the government to demonstrate there is some sort of historical tradition or historical tradition of firearms regulation that's sufficiently analogous to the modern-day gun control law to uphold it or justify it as being consistent with the Second Amendment. Okay, now with that methodology laid out, there's 2 points I would have made to bolster this brief in arguing that things like suppressors, magazines, other items are arms as defined semantically or linguistically by the text of the Second Amendment. And what I would have done is I would have added a citation to Nysurpa versus Bruen to the quote from that case that talks about how modern arms are as protected today, even if those arms did not exist in 1791 when the Second Amendment was adopted. And I would have quoted specifically to bolster the argument that these various things like suppressors and magazines and whatnot are arms. I would have quoted the language that says, by the Supreme Court in that discussion about how modern arms are as protected as arms that existed in 1791, I would have quoted the language that says that any instrument that facilitates armed self-defense is an arm. Because the word instrument in that text of the Supreme Court decision in Bruin from 2022 says that any instrument that facilitates armed self-defense is an arm, right? That's essentially what it says. It talks about the word instrument. The word instrument is really a synonym, if you will, for an object, an item, physical, something you touch. And that would include all sorts of things: triggers, suppressors, magazines, barrels, stock, locks. You see what I'm saying? Any item, physical item, would fall within the definition of an instrument, which is a thing. Now, this thing has to facilitate armed self-defense. It doesn't say, and this is not Mark Smith, 4-box and diner language. I didn't make this up. The U.S. Supreme Court literally said this in Bruin. This is their language, this court's language, the highest court of the land, the Supreme Court. And then they talk about instruments that facilitate armed self-defense. The word to facilitate or facilitate means what? It means to help. It means to aid. It doesn't mean necessary or essential. It doesn't say that something that's essential for armed self-defense or something that's necessary for armed self-defense. It just says something that facilitates armed self-defense, which means to help it, to aid it. That's it. Now, suppressors obviously help in armed self-defense. Magazines help in armed self-defense, and so on and so on. Triggers, foregrips, rifled barrels. You get the point. So, in arguing that these various items are arms textually or semantically in this brief, I would, if I were the Department of Justice, have added that quote from Bruin, because I think that is the final nail in the coffin of the argument in favor of the Second Amendment and in favor of the position being taken by the Trump administration. The second point I would have driven home and made a little bit clearer, and I would have said expressly in this brief that I think could strengthen it in favor of the Second Amendment and the Department of Justice, is I would have pointed out crystal clearly that when you are applying the in common use test, which is derived from Heller, which derived that from the Miller, U.S. versus Miller case in the 1930s, I would have pointed out that it is not the burden of the Second Amendment proponent, of the Second Amendment lawyer, of the Second Amendment arguer, whatever you want to say, of the gun owner. It is not the burden of the Second Amendment community or the Second Amendment plaintiff or the Second Amendment rights claimant. It is not the burden of the Second Amendment rights claimant to demonstrate that any arm is in common use. Why? Because the in common use test arises from what? It arises from the long-standing historical tradition in the United States of allowing for the banning or prohibition of arms that are dangerous and unusual. And because a weapon that is typically used by Americans, or an arm that is in common use by Americans for lawful purposes, cannot by definition be dangerous and unusual. Because it cannot be unusual, it means that the government cannot satisfy its burden to show that an arm is dangerous and unusual. And I think that the slight tweak I would have made to the Trump administration brief in this case of Barnett, when they're talking about the in common use test and these discussions, is I would have said that it must always be remembered that the Second Amendment rights claimant need only sit on his dupa, looking out the window at the birds and the clouds go by, to see if the government can show factually or otherwise that the items they're trying to ban or restrict are not in common use, And this is an extremely important point that I don't think our side does a good enough job on. We mouth the words that the burden of proof is on the government to show a historical tradition of firearms regulation. We mouth the words that in common use test is the relevant standard because if something's in common use by Americans for lawful purposes, it cannot be dangerous and unusual. We say the words true, but what we don't hammer home, and I think the Department of Justice did not hammer this home sufficiently, is that means because the in common use test and the dangerous and unusual standard is derived from the historical tradition of firearms regulation. That's the history component of the text first, history second methodology. The burden of proof is not on the Second Amendment rights claimant to prove that any of these arms are in common use by Americans for lawful purposes. The burden is on the government to demonstrate these items are not in common use, and by extension that they are dangerous and unusual. And the government simply cannot do this. And I think what happens too often is this gets a little conflated and confused. And next thing you know, you have Judge Frank Easterwick being like, where's the evidence that this is in common use? The answer is, I don't need to show it. In a criminal case, for example, as a criminal defendant, I don't have to do anything. I get to sit on my butt and do nothing. The government bears the burden to show that I am guilty of a crime beyond a reasonable doubt. So too, the government has to show that the arms they're trying to restrict or ban are not in common use. They're not in common use. And if they can't do that, they lose the case. Because the in common use test arises from the alleged historical tradition of firearms regulation where the burden of proof is on whom? The government. Again, if I were the Department of Justice, I might have hammered this home a little clearer and made that point a little stronger. Yes, it seems so easy because these weapons are in common use, but it's not our burden. It's up to the government to show these things are not in common use, and they can't do it. But we got to remind the judges of this all the time. And the last quick point I want to make is why did the Department of Justice under Donald Trump, with the excellent lawyers they have, why do we think they decided to file this powerful brief in the U.S. Court of Appeals for the Seventh Circuit in Barnett, and maybe not another case? Well, I think there's two possible explanations for that. One is this is really the first opportunity the Department of Justice had to file such a brief, because the first time it kind of came up since the confirmation of Harmeet Dillon and the confirmation of John Sauer, and maybe this just happened to be the first case they had a chance to weigh in on these issues, and that's quite possible. Because they had already submitted a similar brief in the U.S. versus Peterson case dealing with suppressors down there in the Fifth Circuit. So maybe this is just kind of their first big arms ban cases they had a chance. Or, this is the other alternative, the differential diagnosis for you medical geeks out there. The differential diagnosis as to why they may have done it is because the Barnett case arose from a full-blown trial record and a final judgment and a permanent injunction. And therefore, by supporting the Second Amendment rights claimants in the case of Barnett arising from a trial and final judgment and findings of fact, it's a better, cleaner vehicle to take that case ultimately to the U.S. Supreme Court, because there cannot be pushback like we sometimes see in some cases about whether or not documents and materials in history and records and facts submitted by the Second Amendment rights claimants have been sufficiently proven at trial or in the lower courts or otherwise, and you get into this debate about adjudicatory versus legislative facts, and you avoid all that fight in the Barnett set of cases there, because there was actually a trial and findings of fact made by a federal district court judge who presided over that case. So that's the alternative reason, and maybe it was for both reasons, by the way, but I think Barnett may be the best case to take to the Supreme Court next. It may be the new Snope case. But of course, we need a decision out of the Seventh Circuit before anyone can talk about going to the U.S. Supreme Court. So we'll see. Anyway, folks, hope you enjoyed this sort of deep dive into the DOJ brief in the Barnett case. Again, fantastic brief by the Trump administration and the lawyers there. None of these comments should be taken as criticisms in the least of what they're doing for the Second Amendment or their brief. But I do want to make you the smartest person in the room out there. And sometimes that requires me to give you some additional nuance and information just so you understand how I think. So you get to be the smartest person in the room wherever you happen to be when it comes to our Second Amendment rights. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me at X at @4boxofdiner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking to all of you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.